Good morning. This is Eric Brotman, and I'm here with Jill Snyder, and we are going to have a conversation about losing a loved one, and specifically the financial and legal decisions that we need to make when that happens. Usually, Jill, when you and I get to do a program, it's uplifting and it's fun, and this is, of course, kind of a somber topic. So we'll keep it from being too morbid. How's that? Does that sound fair?
We'll do our best.
Perfect. For anyone who's joining us remotely or during the live webinar, the chat feature is open. We have someone behind the scenes who will be looking through that chat and making sure that any questions you have get answered. And so you can chat us at any point. If it's related to a slide that we're on directly, she'll interrupt us, which she loves to do. If it's not directly related to the slide in front of us, then we'll try and catch it at the end if possible. And with that, why don't we dig in? I think the first slide is, well, it's our likeness. That's us. I don't think we
Here
need to
we
stay
are.
on there. I don't think we need to stay on that one very long. All right. So, Jill, you and I can sort of alternate here a little bit. And in terms of the first steps I should take, why don't you take the first one and then I'll follow.
Okay, sure. So after a loved one dies, obviously, I tell people take care of yourselves and your family first. There's no urgency or emergency to get the legal stuff started immediately. So, first focus should be on the burial and the organizational details for the family. The next step from there is to gather information that can be provided to the financial advisor and to the attorney. So, in um, my world, and I think that this will bring us to the whole conversation of what is probate, which I think should happen early in our discussion today. But in our world, it's very important to distinguish between an individual's assets that will have to go through probate and an individual whose individual assets that will not need to go through probate. So when I deal with families, they think of it as mom's money or dad's money or both of their money. They don't think of it in the same terms that I do, because to them it's just all money that's going to be, that did belong to their parents that eventually will belong to the beneficiaries. But from the legal perspective, anything that is in a decedent's name alone, without a joint owner, without a beneficiary designated, or without being in a trust, will have to go through the court probate process. So for me, it's very important not to just know what somebody has, but how it's titled. Anything that has a beneficiary designation on it, or is in a trust, or has a joint owner who's surviving, will avoid probate. So those assets don't require legal intervention. It's just a matter of gathering the death certificate, bringing it to the financial institution, which I'm sure you'll talk about, and then they will be able to process the transfer to the beneficiaries. Anything that's an individual name basically gets locked up until an estate is opened and someone is appointed as personal representative who would have authority to then access those assets and gather them and protect them and eventually distribute them according to an individual's will or through the intestate process, which means the state's way of making a will for you if there isn't one. So at this point, do you want me to describe probate?
Not just yet. Not just yet. We want to
Okay.
stay with with sort of the first thing to do. And actually, I think your advice to not make this urgent and to spend a little time first grieving and with family and dealing with the things that are in fact imminent that need to get handled. Some of those decisions have to get handled rather quickly. Hopefully, there have been some wishes conveyed by the decedent, but in a lot of cases there aren't, and so sometimes the family's left guessing a little bit. What I would say, though, is the first steps to take really happen before you've passed away. And we're going to talk a little bit about the planning in advance, but really that's where you can make this process as easy and convenient logistically as possible to allow folks time to grieve if that's what they need to do. And so I think the
That's
first
a
steps
really good point.
actually, yeah, the first steps are actually to be very organized and to have good communication in advance. And we're going to talk a little more about what those steps are coming up. Sarah, if you'd advance the slide, we're going to talk about an executor or personal representative. And I'll take this one first, Jill, and we'll just alternate if that's all right with you.
Fine with
The
me.
executor or personal representative of the will is the person who someone has named to handle their affairs once they're deceased. And there are other legal documents that Jill will go into, but in terms of this particular role, this is the person who or people who have been named by the decedent to act on their behalf, to open their estate, to deal with uh, debts of the estate and creditors, to deal with gathering assets, gathering information, and ultimately distributing property. And Jill, you want to add to that? Because I know there's more to it on your side as well.
Sure. The one thing I'll add is that if you don't have a will and you have not designated somebody as a personal representative, the state has an order of priority for who would be allowed to serve in that role. Spouse, adult children, and so forth. Or you can agree to have somebody even out of order serve in your place. The second thing that I'd like to add is because I think people often have a misconception here is they think just because they're named in the will, they automatically become the personal representative. And that's not the case. They need to still petition the court in the county where the decedent was living through the Register of Wills and receive something called letters of administration, which is what gives them their official ticket to access assets again of the decedent. So they can't just show up at a financial institution with the will and say, I'm personal representative. Can you hand this to me, please?
Right. So, and that gets done at the courthouse locally in their jurisdiction, municipality, or what have you. And if I'm not mistaken, those age rather quickly. Like they're a lot of times only good by a financial institution for 60 or 90 days. So sometimes you have to refresh them if that's part of the process if it takes a while.
Yes, that does happen with certain assets, particularly with stocks. They want to see letters of administration within 60 or 90 days, like you said. But once the estate is open, the Register of Wills is always willing to send updated letters if it's necessary to do so. There's not a new application process that has to take place.
And sometimes when folks do their estate planning, Jill, not only do they have the will drafted, but they might have trust drafted for various reasons, whether it's tax reasons or just convenience reasons or dispositive reasons. They also often will have a financial power of attorney and a medical directive. And I think a lot of people don't realize that those expire when you do, and ultimately those are only useful for someone to name, for example, your attorney in fact and a power of attorney. That's only good while you're alive and they're acting on your behalf. Once you're deceased, that document is null and void, correct?
Yes, that's absolutely correct. And it's something that I have to state immediately because a lot of times people accidentally continue to use them thinking they have authority and don't realize that they no longer have authority under a power of attorney as soon as a person dies. The only way to regain authority is to petition the court and become appointed as personal representative.
Okay, which can or may not be the same person. Yeah, you may have
Correct.
named somebody as your power of attorney or as attorney in fact during your lifetime because of proximity, but you've named someone else because of maybe expertise as personal representative. Some people will name a spouse for all of these roles if they're married, and that makes sense logistically, but others will sort of divide that up a little bit. And we'll get to a little bit more about that planning in a moment. Let's go to the next slide. And this is fun because I was going to let you go next, and the next slide is about the financial decisions and then the legal ones. So why don't you let me take the financial ones, and we'll let you take the legal ones. That sound fair?
Sounds good.
Financial decisions. First of all, I think it's really important not to make major decisions immediately. Decisions that are made emotionally or through the fog of grief can sometimes not be the best decisions. And that's true whether you're a surviving spouse and you're widowed, or whether you're the kids or grandkids or other heirs. The first thing I think you do need to do is you need to notify all the financial institutions that someone has passed away. Because as Jill mentioned, it's going to freeze various accounts. It means you can't trade or act upon an account once someone has passed. Even a joint account potentially has to be moved into that individual name of the surviving owner before transactions can be done. So it's really important to notify all of the various institutions. That means insurance companies, it means governmental agencies, Social Security, for example, or Medicare. It means notifying the banks and notifying the brokerages and notifying potentially even HR departments who may still hold a 401k or other type of qualified plan for you. And one of the benefits of having, I think, a financial advisor in advance of this process, ideally, is that he or she can help you figure out the inventory and figure out where everything is so it can make this process a little easier. If you haven't gone through that process, then the first financial decision is inventory. Figure out where everything is. You're going to have to figure out how everything is titled, and some of this used to be going through somebody's mail. But now with so much of it being electronic, it's also real important that you have access to someone's email address, because in the absence of having the login credentials, that can be problematic too. Once you have all of the information you need, you've done the inventory, you know how things work, then certain decisions are largely out of your hands. If, for example, there's a joint account and it's joint tenants with rights of survivorship and somebody passes away, the remaining tenants own that account. You have to take some action, you have to establish the account in their name, but there's no decisions to make. It's just going to happen. If there are accounts that are individual that are going through probate, there may be some jobs for the executor or personal representative to do. And sometimes the decisions are left to kids. If you have four children and your will says, I'd like the four children to go through the house and try to take equally from the furniture and the jewelry and the stuff, well, then some of the financial decisions, it looks like a lottery almost, people trying to choose what's important to them and how they want to do that. And sometimes families get along real well and sometimes they don't, which is why the more instructions and the more communication, the better. Anything you'd add to that from a financial standpoint, Joe?
From a financial standpoint, I can tell you in the planning phase, I always encourage people to try to consolidate to the extent that they can. I sometimes have clients that have assets at 10 different places, and all of them have different procedures, and it makes it really difficult for individuals to have to deal with all the different banks and all the different processes afterward. So the more they can consolidate, potentially, ideally, to have a bank account and a brokerage account and a retirement account, and not have 10 versions of the same things. I think it is a big gift to the family to organize that in advance. The other thing I can say, and a big advantage of having a financial advisor, is if you have individual stocks, those are probably the most nightmarish assets to have to transfer after a person dies, if you have to go directly through the transfer agent for the stock. They require medallion signature guarantees, which is not the same thing as a notary, and a lot of places don't even offer them anymore. Um, and the process is very slow and tedious, where if you have all of your stocks in one brokerage account, your financial advisor can do all the work and without all of that paperwork, and make things a lot easier.
Yeah, and so just to be clear, when you say individual stocks, you don't mean that they own them. You mean that they own them either in certificate form or directly book entry with a computer share, for example, and so it's a
Correct, with the
direct
transfer
dividend.
agent.
So if that's the case, when you see those things, it is helpful to get them into a brokerage account so they can be handled at once. I'd say the same thing's true with things like savings bonds and other physical paper. If you've got a whole safe deposit box full of 20 and 50 and $100 savings bonds, it is so cumbersome to deal with those beyond death. It's so much easier to either sell or consolidate or make other changes to them while you're alive, because once you're deceased, there is an awful lot of process involved in getting those physical documents handled. So, Jill, good
Correct, and
advice.
it's not
Let
just the physical ones, it's if you have to deal with Treasury Direct as well.
Well,
You could
true.
go weeks without speaking to a human being and months before you get correspondence.
I would agree. In fact, with Treasury Direct, that problem's true when you're alive. So when somebody's deceased, it's that much worse. Let's shift to the legal side, because there's lots of decisions that need to be made, and now I think it definitely makes sense for you to take first step.
Okay, I agree. And so, as I mentioned earlier, it starts off as a financial question in terms of figuring out how assets are titled. But once you determine whether or not an estate has to go through probate, And again, that depends on how the assets are titled. It does not matter whether you have a will or don't have a will. Having a will does not avoid probate. It just says where things go when they get there. So if you have to go through probate, of course, I encourage you to seek legal counsel because we can do it so much more easily and efficiently than someone trying to navigate it on their own. But you have to gather certain information to be able to file the initial probate petition that'll have to be filed in order to get those letters of administration. You need the death certificate. You need the original will, or all interested persons have to consent to a copy being admitted. If it's only a small estate, meaning an estate under $50,000 or 100 if the spouse is the sole heir, $1,000, then you need the paid funeral receipts at that point. You should have an idea of what the assets are. You probably need to get a probate bond, an insurance product, which is required by the Register of Wills to protect them in the event that the personal representative runs off with the money. We have to file a notice to creditors, and we have to file a list of interested persons. That is a list of every individual's name and address who either would inherit under the will or who would inherit in the absence of a will. And it often turns out to be a time consuming endeavor. For example, I'm dealing with an estate now where an individual died, didn't have a spouse, didn't have children, parents are long gone, and even all of the aunts and uncles are gone. So we've had to go through recreating a family tree and determining who all of the cousins are and their addresses, and if any cousin is deceased, going down to the next generation. So another organizational tool would be to get your family tree organized so that it's efficient for people afterward when they need to open an estate. So in terms of the legal actual decision, it's just what goes through probate and what doesn't. If there is not a will, then the family should decide who should be the one who should take the lead and petition to be the personal representative. Um, and after that, that's all the immediate work that needs to be done, is to figure out who's going to be in charge if it's not already stated in the will, and gathering the necessary information. I would like to mention there's a tax consideration that should be considered. It can be deferred for a little while, but not indefinitely. But if a person who's married dies, a person, the surviving spouse, is allowed to make an election now called portability, where you can keep your spouse's unused estate tax exemption. That means that when a person dies, if they give everything to their spouse, they're not using up any of their estate tax exemption. So the surviving spouse can say, when I die, I want to be able to give away not just what I'm allowed to give away tax free, but also what my spouse would have been allowed to give away tax free. So even though no estate tax will be due, it should be on people's radar to determine if there's a possibility that the spouse could have over a tax threshold when the surviving spouse dies. They should start communicating quickly and early with an accountant who can prepare the tax return that's necessary to make that election.
Great advice. And actually, I think that that doing an estate tax return and just filing that election makes sense almost at any wealth level, because while it feels like if you're not worth millions of dollars and you're not one of those people where you're concerned about estate tax immediately, the fact is that if a surviving spouse, has some windfall, and it creates a new tax regime for him or her, or if legislation changes adversely, or somebody moves and they move to a state with different rules, there's lots of reasons why you could be pulled into a tax consequence or consideration, even though you may not have initially thought that that would apply to you. Estate tax was designed, I think, initially to prevent the incredibly wealthy humans from keeping all of their wealth in the family without some careful planning. But it really has trickled down to a lot of different folks. And so, and every state is different. So you talked about these legal decisions and all these various things. I mean, I think you're referring primarily to the state of Maryland, but every state has their own intestate laws. They have their own processes. They have their own forms to fill out and their own bureaucracies. And so there's some other things that happen if you have folks with property in multiple states or outside of the United States. That's a whole nother conversation if you're dealing with some international holdings. If you have folks who also have property in Canada or somewhere in Europe or elsewhere, then there are other tax consequences there. So some of the legal decisions that have to get made on a deferred basis, they still have a clock ticking, right? I mean, most estates are closed within 9 months. Is that a fair estimate, or is that not
Well,
always
an
true?
estate tax return is due 9 months from date of death. So that's definite. In terms of opening an estate, Maryland at least does not have a requirement on when an estate needs to be opened. There, it doesn't start ticking, when a person dies. However, there is a clock from the time an estate is opened for when certain reports need to be made and when certain challenges expire. So it's in everybody's best interest not to wait too long because, at least in Maryland, from the time an estate is open, it has to stay open for more than 6 months so that creditors first have an opportunity to make claims against it. So it's a good idea to get things moving just to be able to get that clock ticking. So if anyone challenges the will or if any creditors make claims against the estate, there will be a finite duration when you know that time will end and distributions can safely happen to the beneficiaries.
Excellent. Anything else you want to add on this in terms of either immediate or deferred legal decisions when someone's passed?
Nope.
All right, let's move on. How does a life insurance policy fit into this process, and what should beneficiaries know? Life insurance is one of many asset classes that will be taken into consideration when somebody passes away. And life insurance, typically, assuming the policy is in force, will have a claim at the time of death. Now, some people think that they can cover this in their will or elsewhere. Under almost all circumstances, life insurance should have a beneficiary on it. I can't think of good reasons to allow it to be the estate. But nonetheless, if you have named beneficiaries on the life insurance, that will supersede anything the will says anyway. So if I say, I'm leaving all of my property to Jill, she's my favorite person, but my life insurance policy names my daughter's going to receive the life insurance proceeds no matter what the will may have said. What beneficiaries need to know is that each life insurance policy, each life insurance company will have a slightly different process for the way in which claims are filed. The first step is notifying them that someone has passed. When that occurs, typically a letter will be generated with next steps so that you know what's coming. The life insurance company will typically accept a death certificate. And Jill, you mentioned the death certificate and a few other forms. Before we go on, can you share with folks where to get those? Because you hear, oh, you have to get a death certificate. Where is the best place to get those?
So most typically death certificates are something that you order through the funeral home that makes the arrangements. It's a little trickier if you're donating your body to science, and there will be no funeral home in Maryland. We have the Maryland Anatomy Board, and we have an online division of vital records where you can order death certificates. And typically it costs more money for the first one and less money for additional ones. Maryland has one place where you can walk in and request death certificates too. The important thing is that you have to be prepared to show your relationship to the decedent. They don't just give them to anybody for anybody. But like I said, the easiest typically is to go through the funeral homes because they deal with the division of vital records on a daily basis and make their runs and get a bunch of them in bulk every single day.
And with death certificates, typically you don't want to just get one because every institution will have different rules and many of them want an original sealed document. So we tell folks to get 1 to 2 dozen of them. They're not super expensive, but you will
Correct.
need them. And again, you mentioned having 10 banks. If you have 10 banks, you might need 10 death certificates to send 10 claim notifications to 10 different banks. And that's just one example. Life insurance companies will certainly want those. Qualified plan providers, 401k providers, and others will want those. You'll need them for a variety of different things. So I say get 1 to 2 dozen of them so that you have them. In terms of the life insurance piece, the best thing you can do is to keep excellent records during your lifetime so that people know where these are. If you have to do a search, There are state administration software and other companies that can do a search for you across the entire spectrum of insurance companies and so forth, but that can be a little more time consuming. It can certainly cost money. It would be much better if you have all of your T's crossed and I's dotted while you're alive, so that your family knows, here I have three life insurance policies and here's who they're with and here's the policy number, and oh, by the way, here's the policy. That can make a huge difference. Even though you don't need the original policy to file a claim, it sure helps. So that's
Yeah.
what I would say in terms of that process. Anything else you want to add on life insurance specifically?
Um, yes, I wanted to add number one that there is no easy way to find out where all of an individual's assets are. People say, can we just do a search? And it's not that easy. And even if you pay search providers,
Mhm.
they're not guaranteed to cover everything. So yes, the important thing is to absolutely organize your stuff in ahead, whether it's a binder, a folder, a file cabinet, and make sure people know where to look. The second thing is people need to keep checking their beneficiary designations, because notoriously people tell me what they think they are, and they're not necessarily what they are. Maybe their kids were young and they didn't put them on as beneficiaries initially, or they didn't update after a beneficiary died. And even, more startling is when people die and it turns out that the ex-spouse is the beneficiary because it was never updated. And the current spouse is never happy to hear that the money is going to the ex-spouse. The only happy person is the ex-spouse. um,
Yes, yes, no, that, and it does. It happens a lot. Or you've named one child and then you've had two more and you never went back and changed it. And so you're
correct.
disinheriting two of your kids by accident. It does happen a lot.
Right. And then the final thing that I'll mention, since you mentioned kids, is you have to make sure you don't designate beneficiaries that can't or shouldn't get the money directly, whether it's a minor child or a child with special needs. Minor children cannot get more than a nominal son directly before they turn 18 in Maryland. And even if there's a surviving parent, that parent would have to go through a whole court guardianship process in order to have authority to claim those assets on behalf of the beneficiary. And they have annual reporting requirements and a lot of restrictions on the assets. So you want to make sure that you either have a trust that you can designate as the beneficiary rather than the minor or child with special needs, or for a minor child, you can also designate a custodian for the minor. But just make sure there's some adult oversight. Otherwise, the court is the adult oversight.
Yeah. So you've mentioned two things that I thought were interesting that I wanted to hit on. One is the beneficiary updates and verifying those. One of the things at BFG that we make sure that we do is keep a record of that, and we never take anyone's word for it. We need to see it in writing before it's there. That's not because we don't trust folks. It's because folks forget, and folks make elections, or elections get handled incorrectly by a computer system or by a clerk or something. And so just verifying that they're done. We do employee wellness programs, and we see in these programs so many people don't have beneficiaries on their retirement plans, or their employer health insurance, or sorry, life insurance or other things. Second thing you said is a family tree. I think having a family tree with some of that basic information saves so much time, and it saves so much detective work when the time comes, if you have to start tracking folks down and finding them. We've had situations where somebody's passed and their next of kin is in South America somewhere, and it is not easy to deal with those kinds of situations. And so we have seen that. um, I think we should move on to the next topic, if that's all right with you. And I'm going to let you take first stab at this, and that is, what steps can I take now? What should folks be doing who are watching this and listening to us right now, who are saying, well, I'm alive. What do I need to do now so that when my time comes, which ultimately it will, I'm not leaving anybody in a lurch?
Right. Well, as you alluded to earlier, it's absolutely critical to organize your information so that your family has access to it, both as paper documents and to access your digital life. So, one of them is to do an asset inventory where you make a list of where your assets are, how they're titled, who the beneficiaries are. If you only have online access to those accounts, providing that online access information along with being able to access your phone because there could be verification, authentication that has to be sent to a phone or to an email address. You also should organize your legal documents, which I'll get to in a moment. Um, and then I would say, like we talked about, is to consolidate to the best that you can. My advice for people whose estates are simple and straightforward in terms of being interested in giving everything to their spouse and then outright to their children, no trust, no complexity, is to work on getting beneficiaries designated on everything. There are some that are more obvious than others. At retirement accounts and at life insurance companies, you're used to them asking you for a beneficiary. But at banks, you can designate a beneficiary called a payable on death beneficiary. At a brokerage, you can designate a beneficiary that they call a transfer on death beneficiary. There's actually a way in Maryland to designate a beneficiary for your vehicle online through the MVA online store. And finally, there's something you can actually do with your house to designate a beneficiary. It's called a life estate deed, where you can keep full control over your house for the rest of your life. But upon your death, it can immediately transfer to your beneficiary and avoid the court probate process. So, when your situation lends itself to that simplicity, I would definitely get those steps taken care of. Why make people go through the probate process and have the time and the expense of probate when it can be so easily avoided? Now, in terms of the legal documents that are important to have in place, the essential documents are the will, the living will, the power of attorney for healthcare, and the financial power of attorney. The will is what says who's in charge and where your stuff goes. It can do a lot more than that if necessary. It can control distributions to beneficiaries. It can deal with tax planning. It deals with guardianship of minor children. So it can be as simple or as complex as you need for it to be. And you may incorporate revocable trusts into your plan as well. And then the other documents that are essential to an estate plan are your living will, where you make your own end of life decisions, really as a gift to everybody else, but also to make sure that your wishes can be honored and communicated if you can't communicate them at the end of your life. And then there are your two powers of attorney. There's a healthcare power of attorney. That's for your more day to day medical decisions. And the most important aspect of that document is the HIPAA language that's incorporated into it so that the doctors know who they're allowed to share information with. Arguably, your most important document is your financial power of attorney. I say that not just because it deals with money, but if you don't have a will or you don't have a healthcare power of attorney, the state will make one for you. You may or may not like it. If you don't have a financial power of attorney, nobody, not even a spouse, to everybody's surprise, has access to your separate assets without going through a full blown court appointed guardianship, which is several thousands of dollars, a big pain in the neck, and easy to avoid. So I would, highly encourage people to have a financial power of attorney. Obviously, it's a very powerful document. It allows someone to access your assets while you're still alive. So you don't want to give that power to just anybody, and you don't want to have your document floating around anywhere. But you want to make sure that you have this in place so that if you become incapacitated, there are assets to take care of you, or even for you and your spouse to be able to sell a jointly titled house, or for your spouse to be able to file taxes on your behalf, or to make retirement decisions or elections on your behalf, or to file a lawsuit on your behalf. It's critical to have that.
So these four documents are something that most adults, or basically all adults, should have in the United States. Um, we encourage folks, even folks who are 18 years old, who maybe don't have assets and don't have kids and aren't worried about wills per se, to have a financial power of attorney and to have a medical directive and power of attorney, because their parents don't have the right to do that. If you're a parent with a college age kid, you can't even get their grades without written permission. So you're not going to be able to make medical decisions or handle their financial assets. And so we encourage our clients to have their adult kids, their grown kids, do financial powers and medical powers to name one or both parents to help in that regard, so that doctors and financial institutions will actually listen to them and speak to them on your behalf. Are you seeing a lot more of that now, or is there a
It's very
where?
common, but probably because I
Yeah.
have kids those ages and a lot of clients, my age. So yes, it is very common for me to prepare financial and healthcare powers of attorney for young adults. And people use them. It really comes in handy to have them. And eventually, when we explain to the young adult children that eventually your parents will get replaced with your significant other or whatever, this is just what makes sense for now. And make sure that they realize that they still have all their autonomy, they get to make their own decisions, but somebody can be there to step in the event that they can't.
Right, and that could be an accident, an illness. It could even be travel. It could be that they're doing a semester abroad somewhere and something needs to take place. So this doesn't have to be tragic. It could just be convenient. Um, let's shift and talk a little bit about the financial steps that folks can take to make this easier to handle. And I will start by reiterating inventory, making sure you know where everything is for yourself, which is just a good thing to do for yourself anyway. But it will certainly make a difference when somebody has to come in and handle some of these things on your behalf. It means verifying beneficiaries, which you had mentioned. It means verifying title. The titled assets is incredibly important. Is it joint? And there are lots of different kinds of joint ownership. We don't need to get into all those details here, but there's different ways for people to own property together. And it's more than nuance. It really does create an important distinction. It's important to know that you have a plan around these various things. And I think, in the same way that basically every adult family should have some form of legal advice and some form of tax advice, there should also be some form of financial advice, and being able to have a plan that works if you live to be 103, but also works if you don't wake up tomorrow morning. And that's a really hard thing to think about. None of us want to think about ourselves in a vulnerable state or not being here, but the fact is that happens every day. So taking those steps, doing the inventory, looking at the titling, looking at the beneficiaries, and then starting to put in place a plan for not only your own care, but for the care of your assets. If you are charitably inclined, if you want to do philanthropy, it's real important to include that in some of your planning. That can be done by beneficiary designation. It can be done with different trusts. It can be done under your will. There's a lot of ways to do this. Some are better than others. And then the tax consequences of all these decisions need to be considered, because after tax dollars and pre tax dollars are not the same. So a dollar is not a dollar when it comes time to spend money. Sometimes it has to be taxed first. And so that means looking at these dollars in that way also makes some sense. In terms of building the plan, one of the things to handle the financial affairs is also to include risk management, which is legal and insurance, but it's also other things. It's making sure that there's credit monitoring and identity theft protection and fraud protection and some of those types of things. It means making sure someone has access to your passwords. And you don't want those floating around either. But if people can't access your online accounts, it becomes a serious issue in your absence. Even if you're alive and you're just not capable of doing it for whatever reason, you're in the hospital or what have you, it's real important for someone to be named and for someone to be able to access that data. I think some of the digital estate planning is now more forefront than ever. Jill, are you seeing some of that too in terms of your digital presence, your social media accounts, and all those kinds of things need to be handled in your absence too?
Yes, and digital assets like Bitcoin. But for my clients to say it's more common to deal with, yes, their financial assets and their social, assets, or
Yeah,
their photos and that kind of
right.
thing. And there have been legal changes. For example, in Maryland, you can give specific authority to your personal representative and your power of attorney to access the digital version of your life and not just the paper version of your life. So you don't want someone who's trying to help you to get in trouble for accidentally violating the anti-hacking statutes. So you want to make sure that you give them proper legal authority to access and do what they need to do. And, as we keep talking about, a lot of times there isn't a paper trail anymore. People don't want to pay
Mhm.
money to get paper statements. And so you might not
Right.
even know an asset exists if you go through somebody's files and don't see anything about a specific account because everything is digital. Um,
Well,
I did want to mention when
yeah.
you were talking about the inventory.
Hmm.
There's the inventory that we talk about while you're still living, and so I want to talk about how that translates after you die. So, in addition to obviously wanting your family to know what you have so that they can find it and get to it, there is a legal obligation to inventory assets after a person dies. So, in Maryland, after an estate is open, 3 months from that date, an inventory must be filed with the Register of Wills in the county where the decedent was domiciled that has the exact date of death value with written verification of each of the decedent's assets that go through probate. So it is a lot of work, and you just don't want to make it so hard for somebody at a difficult time to not even know where your stuff is when the clock starts ticking, and they have to gather this information. And the banks don't always give it to you right away. You have waiting periods, and you have to make the appointment, and you have to wait for the papers to come. So you really need to help out the people that are helping you later by having that information. You also need to get date of death values for non-probate assets in certain circumstances. That's true if you're going to be filing the estate tax return to elect portability. You need to get valuations for the house and valuations even on the joint accounts or on the accounts with beneficiaries on them to know what you were worth the day that you died. So I just wanted to emphasize the importance of that inventory because there are legal and tax filing requirements where you have to provide that information.
Can some of these things, particularly large items, artwork, various collectibles, those kinds of things, can some of that be handled by periodic appraisal during your lifetime? Will that be honored, or do you have to do another one at death? How does that
We
work?
have
If
to do it at death. So
you have
if
to
you're
do it
going to be
anyway.
Yeah,
Okay.
so if you're going to be gifting during lifetime, it could have value to do that appraisal, and obviously for insurance purposes, it can be beneficial to have the appraisal. But no, we are required to do date of death values, period,
Okay.
not somewhere in the neighborhood of.
Okay. Well, and some assets are hard to value. Business interests can be difficult to value. It's not always cut and dry. In a business interest, for example, if three business partners are in a situation and they haven't done proper planning and one of them passes away, well, what is the value of their share? Let's assume that they owned a third of the company. We can't necessarily assume that that third of the company is 33% of the value because it's a minority share. So there will
Correct.
be there'll be some negotiation around, well, this wasn't a controlling interest and therefore we should discount it in some way before we pay taxes on it. There's going to be other ramifications around that, and so some of that can be solved with planning in advance for business owners. But some of it's messy. I mean, it really, and to your
And
point,
costly. Those business valuations aren't cheap.
no, they're not. No, they're not. And so some of it is a cost issue. Some of it is a nuisance factor and a logistical issue. Some of it you're going to have to go through anyway. Um, going through your deceased spouse's closet and giving away their clothes and dealing with like is a traumatic and challenging thing no matter what. So we're not just talking about financial assets. You have to do all of the really personal difficult things with some of those things too. So it is a challenge, and the best that we can do as advisors is to sort of grease the skids on the things that we know are predictably going to be there, things that we have to do. And
Yes,
that just
make the
means
legal
making.
and financial parts easy so that people can deal with the personal, emotional
Yeah,
parts.
yeah, and that you have to do that during your lifetime. And one of the things we talked about very briefly was communication. I think having open communication within families is so important for so many things, not only for your vision and your values and your mission and what's important to you, and of course your wishes, but also just to explain maybe why you've made certain decisions. If you have three children and you've named one of them to be your healthcare agent, it's not because you love that one more. It might be because that one's a nurse or because that one lives close by. It could be a lot of different things, but unfortunately, there's baggage around it, and once you're deceased, you can't answer to that. And so I think handling some of the qualitative, some of the emotional, some of the psychological stuff in advance also makes sense. And I am not a therapist. I trust you are also not a licensed therapist. But some
I'm
of this
not, but
comes
sometimes
down,
I feel like one.
well,
I
yeah, I
feel like
play one on TV. It feels like it, but we're not. And so,
No, we're not
um,
trained.
I've certainly I've helped families negotiate challenging things, and things that you think are easy or fair aren't necessarily the best answer. For example, if you have a house at the beach and you have 6 children, and you decide I'm leaving it to all 6 children, they're going to love it, but you haven't had any communication around it, you could have a problem because there might be 1 or 2 kids who want to sell it, 1 or 2 who want to use it, 1 or 2 who want to rent it, and now you have a problem. You have these negotiations that have to happen, and then there's hard feelings, or there's the cost to keep the home, and 4 of the kids can pay their share but 2 can't, so what do you do? And it
Right, that's
creates
a common
acrimony.
issue.
You can destroy Thanksgiving for the next generation just by leaving a vacation property then when you think you're being nice. So
That's absolutely true.
having having some communication about, is this something you're going to want? Does one of your kids want your house, for example, in which case all the kids agree that the house is going to stay in the family and it's going to go to this child, and you can equalize or balance things out in other ways if that's what you want to do. But that solves so many problems just by having communication. A lot of families don't want to talk about money. It's taboo. There's lots of things we don't talk about at the dinner table. Politics and religion are there, but money is also a close second, right? And so if that's true, you don't have to quantify this. You don't have to sit your kids down and say, let me tell you how much I'm worth. But it sure is wise, I think, to sit them down and say, this is how my final affairs are happening. This is what my final wishes are. This is who I'm naming. These are the people to call. Who should you call when you're going to call your religious officiant, a priest or rabbi or what have you? You're going to call your financial advisor. You're going to call your lawyer. You're going to make certain phone calls to folks outside of family when this occurs. It sure would be helpful if your family knew who these people were, because they might have a lot of these answers for you and it could save you trouble. If our clients' kids know that we're one phone call away and we know, oh, they also work with Jill, and we can make sure that some of that happens, it does make a huge difference when the time comes. Anything else in terms of steps to take immediately?
No, I did want to get back to one thing that just we went through quickly and wanted to mention. When we talked about adding other individuals onto accounts,
Mm.
I wanted to at least have a quick discussion about cost basis and explain that there are good ways and bad ways to do things because there are tax consequences to them and other liability consequences. So, a lot of times people hear from their neighbors, oh, I should put my kid on the house, or I put my kids on my stock accounts, and we're all joint owners, so it'll be easy. I wanted to highlight two of the drawbacks of doing it that way. One is the liability piece, which is if you're joint owners with someone, your assets now become vulnerable to all of their problems. If they get divorced, if they run somebody over, if something happens, adverse in that other owner's life, it could affect your assets. And then the second is the cost basis. So when a person dies, a person gets something called a step up in cost basis to the value of what that asset is worth on the day they died. It's as though the asset is purchased on the date of death rather than the date of purchase. So if they've been living in their home for 30 years and their house has appreciated substantially in value, if you die with it, it's as though it was bought the day of death. And all those capital gains from the time it's purchased to the time of death get completely wiped away. If you put someone on as a joint owner with you during your lifetime, only a portion of it gets stepped up because that individual that received an interest while you were living is stuck with your individual with your original cost basis. So as important as it is and to listen to us say get other people on these assets, there are good ways and bad ways to do it, and most of the time a beneficiary designation where they have no rights during your lifetime is far more advantageous than joint ownership.
I would completely agree with that. And there are assets, when you talk about leaving assets to kids or to charity or other things, there's assets that are really, really efficient to leave to family, and there are assets that are inefficient to leave to family. And the perfect example, and so much of this has been legislated in the last half dozen years, but leaving an IRA, for example, to your kids is now sort of a tax time bomb for them, because they no longer have the ability to stretch those distributions through their lifetime. They now have to take the entire account out of the IRA within 10 years. And there's a few exceptions for special needs and for minors, but in general, if you're not the spouse and you inherit an IRA, you have 10 years to take all of the funds out, which means paying taxes on that full account.
And
Well,
they could be
if you have
during
to pay,
high earning years.
correct, not only
Hmm.
could they be during high earning years, they could be during Medicare years. I mean, you
Hmm.
you could be 90 and leave assets to your 65-year-old who's on Medicare, and now that's going to raise their Medicare premiums or cause them to pay taxes on their Social Security or affect other benefits that they might have. If you're leaving assets to your kids who are 50 and they're in their prime earning years, their tax bracket might be higher than yours. So leaving those assets to those kids could affect them. If you're leaving an IRA to kids who otherwise might have qualified for financial aid for college, by having to take those IRA dollars and redeem them, they're essentially going to have a higher tax bracket, a higher tax return, and maybe not qualify for financial aid. I mean, there's a ripple effect here in lots of ways. So doing planning around the disposition of your assets is almost as important, if not equally important, to how you're going to manage your assets while you're growing them and how you're going to manage your assets while you're living on them. Then it's also a decision around how do we leave these. And some of that is charitable planning, some of it is trust planning, some of it is lifetime gifting. There's lots of strategies that go way beyond the scope of today's conversation. One last thing I wanted to throw out, and you talked about creditors and you talked about leaving, have 6 months to potentially dispute a will, for example. Wills are public. Wills are public documents. If you leave a property in your will, anyone who wants to can go to the courthouse essentially and see what that will said. Trusts are not public. So sometimes, even if there aren't tax consequences or tax ramifications, the reason to use certain types of trust is to have privacy so that you're not putting in the public eye, hey, my daughter's about to inherit $2 million, and then she's on every list for every predator who could be out there because now they know she's received this property. Sometimes it's better to be private. Are you seeing some of that? Is privacy an issue that you deal with much?
For some people, it is an issue. I would say most people's lives aren't that interesting and no one else is going to care. But
Sure.
the thing that really scares people that they aren't aware of, they talk about the will being publicly available. The will doesn't always say a lot because the will is kind of the catch all for all of your assets you have to go to individuals. You're not naming specific assets in many wills. So, although it says I give everything to my spouse and then my kids, people don't know what they're getting. What they can also get that's public, that is the downright scary thing, is that everything that goes through probate, that inventory that I said has to be filed with the exact date of death value of every single asset, that is also publicly available. For 50 cents a page, you can download it on anybody you want with no verification of any relationship or anything through the Register of Wills website in Maryland. So that's what I think people should really think about, not the will, it's the inventory that becomes public.
Lots of wisdom here, Jill. Thank you. Let's go to the next slide. We've put together an executor checklist that is designed to help a little bit with the things to consider doing during your lifetime, and then what you need to do as an executor or personal representative. If you use this QR code, it's free to download, and there's some legal and some financial steps that you may want to consider taking. This is designed to be a guide. This is not legal or financial advice, but it's a guide that you can use and things that you can discuss with your own financial advisor or your own attorney. And of course, you're also welcome to contact Jill's office or ours anytime. Are there any questions that came through in the chat while we have a couple of minutes before the end of the hour?
Not
Sarah?
yet. If anyone has any questions to send, feel free to drop those in the chat now. And in the meantime, I will throw the contact
Perfect.
information up.
That is how to reach us. We would certainly love to speak to you and see if we can be a resource. And of course, this replay will be available, so we'll make sure that it's sent to you and that you can share this with loved ones as you'd like. Jill, any closing thoughts? No questions. That means we were perfect in every way.
I think we must have explained everything everyone ever wanted to know.
Oh, well,
So,
there's the legal slide. Let's go back to the contact slide. There we go. Now we had the legal slide on, so we're good. Um, all right. Well, thank you. Thank you as always for your time, for your wisdom, for your thoughtfulness. I always enjoy working with you. I know we have lots of clients in common, and you've been a wonderful resource for us, for our firm, for our clients. And I can't thank you enough for taking time today to do this.
the feeling is mutual. Thanks, Eric, for having me.
Thanks, everyone. Take care now.
Bye.